Several concepts from law and psychology influence rights in the employment relationship, including employment at will, wrongful or constructive discharge, just cause, due process, and organizational justice. Employment at will is a common law doctrine stating that employers have the right to hire, fire, demote, or promote whomever they choose unless there is a law or a contract to the contrary, and employees can quit at any time with or without notice. National restrictions on employment at will include prohibitions against the use of race, age, sex, national origin, religion, and/or disabilities as bases for termination. Wrongful discharge refers to the termination of an individual's employment for reasons that are illegal or improper. Constructive discharge is the process of deliberately making conditions intolerable to get an employee to quit. The courts have recognized certain exceptions to employment at will as follows. The public policy exception holds that employees can sue if fired for a reason that violates public policy. For example, an employee who was fired for filing a complaint with OSHA can sue the employer. The implied contract exception holds that employees should not be fired as long as they perform their jobs. Long service, promise of continued employment, and lack of criticism of job performance imply continuing employment. The good faith and fair dealing exception suggests that a covenant of good faith and fair dealing exists between employers and at-will employees. If an employer breaks this covenant by unreasonable behavior, the employee may seek legal recourse. Over the past several decades, many state courts have revisited and revised employment at will contractual provisions. Some courts have placed limits on the doctrine, including situations when employers act harmfully towards workers.